Good morning, Advocate Lapuskarne.
Good morning, CJ.
How are you?
I'm very well, thank you. And yourself?
I'm fine, thank you. You hold 4 degrees, all which you obtained cum laude.
I must confess the last one was the upper second. That wasn't cum laude, that was in Cambridge. But the
Now I
others were
feel
cum
better.
laude.
Okay. Or a BCL, a BA honors, an LLB, and the LLM, for which you did not get the honors. Okay. You did articles successfully, but then chose not to join the sidebar.
That's correct.
You started practicing as an advocate in 1988 already,
That's correct.
and you've been at the bar since.
That's correct. So for the year that I went to Cambridge.
Yes. Is that the Johannesburg bar?
No, Pretoria.
Sorry, Pretoria, yes. Okay. You explain in your application form that your practice or your junior practice included matrimonial law, criminal law, labor law, personal injury law, and the spectrum of commercial law, including, and I'll just mention the ones that interest me: banking, insurance, and construction law, and intellectual property law.
That's correct.
And you've done pretty much everything, I take it. And you've also sat in arbitrations.
I appeared in arbitrations, and I've sat as the arbitrator as well.
When did you take silk?
2006.
Okay. You mentioned that you also sat as a member of the Labour Appeal Court prior the Labour Relations Act.
That's right, yes.
Was that frequent?
A few times, yes. I was doing quite a lot of labor at that time.
Okay. Well, you are credited for leading the transformation initiative of bringing in Black Junior Council into your chambers, and not ending it there, but mentoring many Black junior advocates in Pretoria. Is that so?
That is correct.
And you have participated in the pupil training committee as well?
That's correct, yes.
Okay. You also lectured at the University of Pretoria.
Yes, that was...
That was before, was that before you served articles?
Yes, it was while I was doing my LLB. I was doing a BA Honours in Latin at the same time, and I was a junior lecturer in Latin at that time, when Latin was still a compulsory subject for LLB as well.
Yep. So you've practiced for 36 years?
Yes.
And for how long did you act as a judge? Have you acted as a judge?
Yes, it's 19 weeks.
19 weeks, which is not a long time.
It's almost 5 months, yes.
Yeah. What kind of work did you do during that? Was it one acting stint or a collection?
No, it was spread over a number of stints. And there is a breakdown which the JP has provided of what I've done. The only aspects which I haven't been involved in as a judge is in respect of the tax court and also the criminal trials themselves. I've done a few stints in the appeals of criminal matters.
But no criminal trial as yet?
No trial, yes. As junior counsel, I have appeared in criminal matters representing defendants, but I haven't presided.
Okay. And you claim to have written about 50 judgments during those stints?
That's correct, yes.
Okay. Any of those reported?
Not that I'm aware of. I find most of them on Safely. I haven't checked whether they've been. They're in the law reports that I couldn't do.
And you don't have any reserve judgments?
None.
Okay. All right, I'm going to hand over to Judge President Mlambo to take you through the paces about the rest.
Thank you, CJ.
Thank you very much, Chief Justice. Good morning, Advocate Labuskakne.
Good morning, JP.
Let's just place on record that you are also here because of discussions between yourself and myself in the last 2 years.
That is correct.
When you raised your hand then that you'd like to become permanent, and then I said to you, I will give you the nod when I think the time is right for you to come and face this body.
That is correct.
Right. My spreadsheet that I've given to the commission misses 5 weeks. You say you've done 19 weeks, and I apologize for that.
Yes. 2006, in the year in which I took Silk, I did 2 weeks, and then again in 2008. There's another 2 weeks.
Those are the two. That's two. That takes it to 18.
There's a week missing which I can't find.
Okay. Well, 2006, 2008, I was a puny judge, so I don't know what happened then. But anyway, sorry about it.
Yes.
The moral of why I'm asking this is, in my spreadsheet, you've done 3 agent court weeks.
That's correct.
That was in Pretoria.
Yes.
Was it during term or during recess?
They were during term.
So you would have faced the full load of the agent allocation.
Yes, I was there at the time when there were only 2 judges.
Yeah. And then, well, the commission knows the average allocation load in the agent court. And then you've done 2 special motions.
Special motions, yes, I've done 2. That's right.
Yeah. If you think you've done more, you must tell me, because
yes. Well, those were where I was on the roll, the duty roll for that week. I just mentioned, JP, that as far as criminal appeals are concerned, the spreadsheet misses 1 term in 2021 and another one in 2023. I did 2 stints with criminal appeals.
Thank you very much. And then in terms of opposed motions, I've got 3 weeks here.
That's correct, yes.
Yeah. Now, what you said to me when we spoke about your availability, I said, my preference in giving the nod to candidates to avail themselves for judicial appointment is that in the sunset period of your acting, I would like you to do a full term.
Yes.
You remember, and you told me that it would be difficult for you to give me a full term because of your practice.
Yes, I have a very busy practice, and the overheads are such that to be away for 3 months casts a shadow of another 3 months. It's effectively being out of private practice for 6 months. It's just too expensive.
Yeah, but I think what you said, which I think is justified, you said what compensates for not doing a full term is that your practice is predominantly, if not entirely, high court practice.
That's correct, yes.
Right. Thank you very much. And in terms of the judgments you've written, the spreadsheet I have, or the document I have, does not indicate the periods. But I think in one of the answers you gave to the CJ is that you give judgments timelessly. But have you given, or let me ask you this, have I ever confronted you about reserve judgment?
No, JP, my judgments are done by the time my acting stint is over.
I see. So all of them within 3 months?
Yes.
You've never had occasion to go beyond 3 months?
Well, a few days perhaps afterwards, if applications for leave to appeal would come in, that I would hear later, yes. But I've made a point of being prompt.
The judgments themselves?
The judgments are finalized.
Within 3 months. I know there's one leave to appeal that you did when you were somewhere in the US. Was it the US?
That was correct, yes. It's the first matter I was referring to. It's the United States Polo Association. It was a fight between trademark competitors, and the one was contending that the other's goods in the harbor are counterfeit.
Yeah.
And 3 judgments flowed from that. One on the merits, a leave to appeal, and also a Section 18(3) application. That's the one on which I was overturned in an automatic appeal.
Yeah, and that's the beauty of virtual hearings and case lines.
That's correct, yes.
Thank you. Well, yesterday, Deben Kanzel was singing the praises of case lines. I wonder why Gauteng Kanzel are so muted about the system, because it kept their bank balances okay during COVID, you know.
Yes, case lines is a lifesaver. I would advocate its rollout countrywide.
Yeah. So it may sound repetitive and annoying to some commissioners, but I have a scoring matrix
Yes.
in terms of how I score candidates. One of them is how the interview itself goes, but in terms of your exposure to complex work, like the special motions, the opposed motions, as well as the agent court,
Yes.
right? As well as how you handle the work and turn around in terms of judgments.
Yes.
I've weighted that one heavily. It's got a scoring of 7.
Yes.
How much would you score yourself?
JP, it's a subjective thing. I think I did well.
You think, okay, that's fine.
I would certainly not go less than what you've suggested. I might suggest more. But that's
Okay.
me, my objective opinion. Oh, I'm just joking.
Okay.
No.
Thank you very much.
No.
Thank you, CJ. No further questions.
Thanks, JP. Premier?
Thanks so much, Chief Justice. Good morning, Advocate.
Good morning, Premier.
Premier. You responded in the positive when Chief Justice said you are a champion of transformation in some of the legal work that you've done. I need to get outside that if we have ever promoted any form of transformation and where outside your workspace.
Outside of the?
Workspace.
Look, I've been involved in as a pro bono advisor to indigent people in the city centre for more than 10 years on a regular basis. That was aimed at assisting people who can't afford legal help, who are destitute and desperate. So I was involved in that for many years. Was also involved in training. I helped the asset forfeiture unit to get their advocates ready for court appearances and to teach them courtcraft in advancing their own applications. And as far as training is concerned, it's something that I enjoy. And whenever I've worked with juniors and young advocates, not even where they are my juniors, even where they just ask advice, I'm known to have an open door policy, and there's a steady stream of youngsters who tap into my experience and my willingness to assist. And many, if not most of them, are black.
No, thank you. In the questionnaire for candidates, you proudly stipulate that the DA was outlined to secure the release of the former public protector's report. But you further indicate that you represented a formation that you don't declare in the diplomatic immunity case against Ms. Grace Mugabe. Why you are proud to declare the representation of your client in the form of the DA, but on the Grace Mugabe case, you are not declaring who's your client?
Yes. Could I just correct, when I state that I acted for the DA, it's because they instructed me. I'm not doing so as a matter of any pride. I was sitting right next to Advocate Nguka Tobe, who was representing the EFF in the same application. I think we had the same vantage point, and we were arguing the same issues. That was an interesting case where, for once, there was a unity amongst political parties who seemed to be at loggerheads on everything else. So that was an occasion when there was an alignment as far as legal approach was concerned. I happened to have been instructed by the DA. As far as the matter of Grace Mugabe was concerned, the case is cited as the DA. There were actually two applications. I was in a separate application representing the complainant, Ms. Engels, and also AfriForum, who brought a similar application. They were heard at the same time. But you will not see it in the citation. That's only for that reason that I didn't think it's necessary to.
So your client was AfriForum?
AfriForum and Ms. Engels, who was the complainant in the criminal case.
So why didn't you state it that your client is AfriForum, but when you're representing a DA, you proudly stated that you're representing the DA?
Yes, no, there's nothing sinister about that, Premier, and I've already addressed the issue whether I cite it proudly or not.
Thanks.
Commissioner Hassan?
Thank you very much, CJ. Over here, Advocate. I have two questions. I'll start with the first, relating to the UDM versus ESCOM case. And let me caveat and begin by saying, I think there's general agreement from all sides of the table that load shedding is prejudicial to the country, of course, to specific sectors of public institutions, etc. I think we're all in agreement with that. That's not where my question is situated in. I think my concern, and maybe I should also say this, CJ, that I am also on the portfolio committee for electricity and energy. Yes. So very much involved with the NERSA issues and upcoming electricity tariffs, and perhaps maybe, let me say, very passionate about how we bring about equitable access to electricity. CJ, my question relates to the separation of powers and to, I think, very difficult legal jurisprudence that has been developing over the last few years. And while we can agree there was a need for intervention on this particular matter, I am a little bit concerned by judgments that are handed down that are frankly impossible for the state to implement. And let me explain or expatiate a little bit. We agree that police stations, schools, hospitals, etc., should not be load shed. I don't think there's anyone who disagrees with that. Yes. But the way the grid is designed, we can't just not load shed one particular corner of a street, right? The way the grid is designed is not that. Yes. And for us to literally redesign the grid would cost us trillions of rands that we do not have in the fiscus. And yes, there's an argument to be made that we're now developing transmission, etc. But I do think that and I've read the case before coming here today. So I'm trying to separate a constitutional issue with the practicality of what is possible and is not possible. And where do we get to a point where we are handing out judgments or handing down judgments for legal jurisprudence sake vis-a-vis the actual protection of the people we're trying to look after? And I'll say this by saying, if the grid collapses, and there is a blackout in this country, forget schools and police stations, you have civil unrest. And those were the kinds of contentions that we, and let me not say I was not there, I was in the legislature, but that were having to be balanced out. And I do wonder, Advocate, whether those considerations played a part. And I'll say it openly, I do wonder when there is a need to overstep the separation of powers. We agree there is sometimes a need. But then the immediate pulling back. So you overstep to make a decision, yes, understandable. But then make a decision that is impossible to implement. And then again, we want to talk separation of powers. Then it's the executive that must implement a court order that is impossible to implement. So I'm just interested in the comments, CJ, and then I'll ask my second question. Thank you.
Yes. I think yes, I know which judgment you're referring to. I think one must bear in mind that if there was an overstepping of the mark by the court in granting an interdict of that nature, that there is an appellate process where corrective measures could be taken by the higher structures in assessing the reasoning of the court or quo. I'm not aware whether that matter has gone that route or not. When it comes to separation of powers, it's obviously an important consideration to ensure that there isn't judicial overreach. That does of necessity require a weighing of interests. When it comes to formulating a remedy, however, it must, I think, in principle, be capable of execution. And if it does overstep the mark, it must meet the test of being an exceptional circumstance as set out in OUTA. It cannot be a knee-jerk position to assume. It would really be exceptional. Now, I think as far as load shedding is concerned, it's been a bane of our existence for much too long. There are judgments about it, I think, in 2013 already. And the fact that it has been around for so long is really a matter of great disappointment to everybody. The solution to that, unfortunately, doesn't lie in the courts. And I think that's where courts have been trying to, I think that same judgment says the courts cannot solve load shedding. But when it comes to prioritizing who gets electricity, I think the court in that instance tried to take a position. Whether it's possible of execution, I don't know whether that was properly before the court. In the matter in which I was involved in, which was one of the related applications, we were really advancing the position of public participation in determining the allowable revenue of Eskom, and where our position was really that when NERSA itself would report 6 months before that there were billions of rands of misappropriation and within Eskom, and now has to determine allowable revenue, is it a valid question to ask whether they should be put into place precautionary measures to avoid the public purse being deprived of the benefit of public contributions? So that was a vantage point, which I think it's still to be crystallized, but our vantage point was to have the public be heard on these important issues prior to NERSA determining an allowable revenue.
Thank you, CJ. My second question, and maybe just to say that before, one of the reasons why we've put a stop or been able to put a stop to load shedding, different to load reduction, is actually, and maybe it is important to say, not because of the rulings of that particular case I cited. It's fundamentally because of the ingenuity of Minister Ramokgopa and the team. And why I'm saying that is it could be conflated that the issue of load shedding now is different because of the case. But CJ, my second question relates to, and I'm looking for it here, because as you can see, I have a lot of documents to try and find it. But just to be clear, Advocate Labuschagne, did you act in any cases involving the University of Pretoria and fees must fall activists or students?
Yes. I was involved on behalf of the University of Pretoria over many years, and the fees must fall campaign was part of it. Yes, that's correct.
Thank you, Advocate. Let me also caveat the next question by saying, which we all know, I was a foremost leader of Fees Must Fall at Wits University, a different institution, but the question is important nonetheless. Advocate, what are your views on the bullying tactics, not only by universities using top legal counsel to bully arguably a very marginalized group of people, students, who were exercising a very legitimate right to protest in view or really in finding the objective of free quality decolonized education? And I say that fundamentally because when you're a student, you have nothing. You have no money. And I'm very interested, Prof. Mr. Mangena also raised this around student housing earlier. You don't have much to leverage off with. In fact, the only thing you have to leverage off with is your potential to graduate and contribute to the economy. And I will also say that we had no money to find any sort of legal counsel. And when universities came to us, and I'll tell you an important moment during Fees Must Fall, there was a legal counsel who came to me while protesting. It's got nothing to do with you, Advocate. I'm just trying to give context. Who pointed at me and a number of other students and said, "This is the end of your legal career. We will prosecute and we will move to the very end. And there are many instances of student activists and student leaders, Kanya Eshe being one of them, Bonginkosi Kanyile, and many others who have lost every opportunity given to them because of some of the cases that emanated from those initial days. So I'm just interested, Advocate, in your thoughts around the bullying tactics of universities and council who also seek to bully the most marginalized of society.
Okay, could I address that issue from two vantage points? The first would be that in formulating applications on behalf of a university that is facing paralysis as far as lecturing is concerned and a threat to the exam program being completed. The formulation of the application and the relief sought took very careful notice of the right to protest. It's an acknowledgement. With a legitimate gripe, you have a right to protest. The question is, however, how do you exercise that right? And there, unfortunately, there were instances of criminality. There were instances, if you speak of bullying, of people walking in and hijacking classes where people were about to write their exams. Now, that type of conduct, although it makes a point, also oversteps the rights of other students to be educated. They have, after all, paid for it. So the right to protest is a right that needs to be exercised within the law. And the purpose of those applications was to ensure that that right is exercised in a way that doesn't paralyze the university, but doesn't limit their right to express whatever position they want to advance. So there was a balance involved. And I certainly don't see my own involvement as a matter of bullying. I think we were quite sensitive to the rights of students, and we were trying to balance the rights of other students and of the university to discharge its obligation of training students and affording them an opportunity to write their final exams.
I realize that I may have done you a disservice and sold you short. When you responded to my question about your acting stint that you had acted for 19 weeks, you'll recall the comment I made that that's a particularly long period of time. But then you have a vast CV, which I did not canvass. There are many aspects of it that I did not canvass with you when we spoke. And that includes features such as that in your 36 years in practice, you regularly appeared in our courts, especially the Supreme Court of Appeal and the Constitutional Court. Those are your stomping grounds.
That is correct.
And you've appeared in other courts across the borders as well on commercial matters.
That is
and
correct.
Your arbitration work actually straddles continents. You've worked in countries such as China, in Asia, and Europe.
That is correct.
Mm-hmm. And you are also a published author with a knack for writing children's books.
I write children's books.
And a painter.
That is correct.
And a marriage officer. All right. Oh, I did not see that hand. JP Tlalezi?
Yeah, just one aspect here, Mr. Labuskachne.
Yes, Commissioner.
Yes, I do not know whether you have attended any of the seminars or training under the auspices of SAJE, but practice has over the years has shown that counsel who come onto the bench with such vast experience do not participate at these seminars. Most of the time is that I don't think there's anything that I can still be taught at this stage, and it's normally being done during recess, and they see their recess period being more valuable to themselves and not attending this training. And one advantage of attending these trainings is that you are able to share your best practices and experience with other colleagues who are participating or attending and not necessarily being taught. Now, I'm not sure whether will you be amenable, if appointed, that you will also make a contribution by participating and also subjecting yourself to be trained in the judicial sphere. Thank you.
Commissioner, I've always been a team player, and during my acting stints in the division in which I acted, there are about once a week there are lectures for judges during lunchtime to bring them up to speed, and I attended those during my acting stints and found them very valuable. I have no reason to doubt that if offered an opportunity to attend these type of training sessions, I will first of all make myself available to be trained. I'm not above that, and I would, in time, if my skill set is recognized, I would be able to assist when asked.
Thank you, CJ.
Thank you, JP. Hands are suddenly coming up now. Commissioner Muiman.
Thank you, CJ. CJ, just one question from my side on the greetings to yourself, advocate.
Sorry, what must I do?
I was just greeting.
Good day to you, Commissioner.
Thank you, Advocate Namaskar. Just one question that I wanted to pose to you in relation to SAM versus Minister of Kokta and Salga.
Yes.
The limitation clause.
Yes.
And the freedom to associate.
Yes.
Because I believe this was at the center of that judgment. And the Municipal Systems Act was set aside on the basis of the fact that it contravenes the right to associate, and it limits the political rights of a municipal official.
Yes.
Yes.
That matter was argued about 2 weeks ago in the Constitutional Court, and we are awaiting judgment.
Okay.
So it went further. At the time of my application, the judgment had been granted, declaring that Section 71B unconstitutional. The impact of that section is that it precludes staff members of any municipality from holding political office. And that it is that aspect of their Section 19 rights which is limited, and the argument was, can it be justified? I can go into what the counter arguments were, but the Constitutional Court will tell us in due course what the right answer is.
I'm interested in the counter arguments because there's no right that is absolute.
There's no?
There's no right that is absolute.
That is correct, yes.
Yeah, because you can imagine a municipal manager who's at the same time a regional chairperson of a particular organization, the influence that you will have over the same political office bearers that must exercise oversight over him.
There is a risk of paralysis of a municipality due to political infighting. And the purpose of that act was to depoliticize local government and to professionalize local government positions. The counter argument was that it was a sledgehammer approach to holding political office, whereas the argument in the Constitutional Court was that there's a balancing to take place. There are a few members who hold political office, and what one does by proscribing it is to remove the prospect of manipulation of the superior position they hold as against municipal managers and councillors in a manner that disrupts functioning, because that in the end affects service delivery. And we know that service delivery is a very emotive matter which can easily escalate into violence. So the argument was that for purposes, although it's a small limitation of rights, nevertheless of a right that is significant and what was one It was hardly fought for. But the countervailing argument was that you get millions who benefit through better service delivery if the municipality is not paralyzed by infighting.
Thank you, Advocate. Thank you, CJ.
Commissioner Mkaito?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
I just want to confirm that you and I have been on the same side and also on opposing sides.
That's correct. You want to talk
Yes.
about the last one?
Yes, I know. But just a general point on the discussion with the Premier.
Yes.
I mean, there are times when an advocate gets too close to the client and they lose objectivity, which is harmful to both the advocate and the client.
Yes.
But that's not the general rule. The general rule is that you are not the spokesperson of your client. You are its advocate.
That's correct.
And you are detached from the client. And
is-
if you've acted for the DA before or acted for AfriForum before, that's just part of who you are as an advocate.
Well, I might indicate that I've acted for premiers in the past as well.
Thank you.
Was that all, Commissioner?
Yes, it was all.
Sorry, CJ.
Yes, Premier?
I think Advocate Mugaitobi got me wrong. I'm not questioning who Advocate Labuskaghni was representing. I was just asking disclosure. That's the only area. That in another part it was disclosed, but on the other side it was not disclosed. Representativity, I understand that fully. I just felt let me clarify that.
Yes, well, perhaps then I should make a different follow-up. Was there any specific reason for mentioning the DA? I'm not sure if you didn't mention AfriForum, but so
I thought the candidate answered the question. He said there was nothing sinister about his intentions. I'm not sure what.
no, then I'm
further
happy
will
then if
achieve.
that is where it ended.
Yes.
Commissioner Pillay?
As a follow-up,
Yes,
to that,
Commissioner Nkonyane.
I was tempted to ask. Good morning.
Good morning, Commissioner.
Advocate. As a follow-up to those questions, I was just tempted to ask you: do you belong to any political party?
I don't. I don't, and I never have.
Commissioner Pillay?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
Mr. Mullins wrote a very interesting letter. We won't deal with much of the contents. There's one issue I do want to raise with you.
Please.
And you know that I represent the profession.
Yes.
And some of the feedback we've got from members of the profession, particularly in Pretoria, is that we should probe the commitment to transformation criterion.
Yes.
I see that Mr. Mullins says that his office is down the passage from yours, and he sees that majority of your juniors are black.
That's correct.
Do you confirm that?
Yes. Yes.
And these juniors are being used in matters of substance, etc.
Very much so. I've had the wonderful opportunity of introducing some of them to attorneys, very large firms, and they are being briefed on their own because they've turned out to be brilliant and they're doing well, and that gives me great joy.
And there would be no reason to your mind, Advocate Labuskaghni, that there should be a concern about commitment to transformation?
No. I've done that for many years without any hope of being recognized for it. I do it because I believe it's important.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. I've not seen any hands from the virtual platform. Any questions from there?
Thank you very much, CJ. Can you hear me?
Yes, we can, Commissioner Marumachai.
Yes. On the last occasion, I struggled. I think I was not audible. But anyway, good morning, Advocate Labuskaghni.
Good morning, Commissioner.
I see that you, on your questionnaire, you say that most of your work is on administrative law and by extension, constitutional law.
Lately, yes, that's correct.
Yes. I just want to ask you a question that to some seems to be very clear, that our administrative law and in particular administrative action jurisprudence has developed to such an extent that we can say we now know when PAJA is applicable and when it is not applicable. But when one reads most of the judgments that are coming up, there seems to be some inconsistency on this too. I just want to get your view with regards to the development of the jurisprudence thus far. And what I think it's a triangle between PAJA, the Constitution, and then the principle of legality. In your own view, where are we as a country from a jurisprudential point of view in relation to judicial review? Do you believe that it is clear, you know, when you are having an issue, want to review a particular administrative action, you can go one way or the other, or do we still have some challenges in terms of the clarity of the jurisprudence? Thank you, CJ.
Commissioner, if I might just deal with it from what I think is a watershed judgment, was the Gijima judgment. And in terms thereof, organs of state do not utilize PAJA for purposes of self-reviews. It is done in terms of legality. That has clarified the position as far as most organs of state are concerned. So it's a legality test. You don't have to go through all the requirements, time-wise, etc., as far as PAJA is concerned. In the field of administrative law, the development of the jurisprudence under PAJA and under Section 1C of the Constitution, the rule of law provision, has been one of the immensely interesting things. It's almost like two parallel systems, but each one has its function, and I think that Gijima judgment has indicated which one applies where.
No, thank you very much, Advocate Labusdaf. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Notius?
Yeah. Good morning, Advocate.
Good morning, Commissioner.
Yeah. Look, I just want to ask you, because as a High Court judge, you will often preside over criminal cases.
Yes.
Just can you tell me, in the application of minimum sentences,
Yes.
what are the limitations of the sentencing court, if any limitations?
Yes, this is obviously an issue which would arise in the conducting of a criminal trial, where the issue arises from the charges and a conviction. I've indicated that I've not presided over a criminal trial of that nature. However, as far as minimum sentences are concerned, there is always a tension between whether it is appropriate to apply it in a certain instance and whether there are considerations as to why they are mitigating considerations. And that's very much a factual consideration. The determination of whether the minimum sentence is applicable, will be applied or not, is dependent on a factual assessment of whether there is sufficient reason to deviate, as will be provided for in the section providing for the minimum sentence.
Is it not that the court must move on the basis that the Parliament has prescribed a sentence, that is, has ordained a sentence which must be imposed, and then you undergo the second part?
Obviously, the default position would be that a conviction attracts the minimum sentence. That would be so. It is a matter of legislative implementing the legislation. You are correct. Question whether it is appropriate in those circumstances is, however, part of the judicial function, because we must bear in mind that as judges, we are administering justice, and assessing the facts would be part of considering whether it is appropriate or not.
Yeah, I'm not sure about that part, but let's move. The second question relates to customary law.
Yes.
Is it competent for a court
in the adjudication of a customary law dispute to invoke the principles of common law. That is, we are adjudicating a matter of concerning customary law. Is it appropriate to invoke the principles of common law in deciding that matter?
I think that the answer will lie in the provisions of Section 39 of the Constitution, which determines that when you are interpreting either common law or the customary law or statute, and they are separate areas, you have to apply the spirit and the purport and the object of the Constitution. So I think when it comes to determining an interpretation of of customary law, one does it through the prism of the Constitution. I think it would, in principle, be incorrect to step over into the next body of law when it's not applicable, when it is a matter of customary law which needs to be determined and applied. I don't think common law, as a first comment, would find application unless there are compelling reasons. But in principle, it sounds to me that you are mixing apples and pears. You've been asked to decide a customary law issue, so do it.
Sorry, Chief Justice, can I just get clarity? I'm not sure, Mr. Labuskaghni, if I got it right. You're saying it's permissible or it's not permissible?
My vantage point was that if you are busy dealing with a customary law issue, it must be accorded the full value that the Constitution accords to it.
You've answered me. Thank you.
Yes.
Right. Well, it seems we've exhausted our questions, Advocate Labuskaghni. Unless, is there anything you wish to raise with us?
No, thank you.
All right. Well, thank you so much for making yourself available for this vacancy. And I have to make this comment that it's rare for our top lawyers, which you are, that's a fact, to make themselves available for the bench. And we know what the challenges are. So we always appreciate it when someone like you does make themselves available. And we hope this will encourage, I hope they are listening out there. It will encourage our top lawyers, especially the black ones, make themselves available for the bench. We know the pay is poor, but we are drowning. We need our good people. Thank you,
Thank you for
Advocate.
the opportunity. Thank you, CJ. Thank you, Commissioners.